This is the procedural part. Now, when this matter, the final order is going to remand. So really speaking against the remand.
Where is the operative?
Yes, my Lord, that will also be
Para 18.
Para 18 at page 495 of my volume. In view of the discussion made in the aforesaid paragraph, this court is of the opinion that the regulatory commission has to undertake process revision either so moto through an application when he filed with the or through an application when he filed with so and so and conduct the educated process by issuing notice to all citizens after hearing parties, decision taken by according to law. Compliance with that has been continued in the business admission.
So the court accepts that the power exists, except
Yes.
the procedure was not properly followed.
Power exists, Lord, as it has been done in the other case. But in our case, Lord, it is not done even procedurally.
Now, how the division?
Now, Lord, my first submission is against this kind of a remand. Why should there be a let us find an appeal? What has the court done at the end of the day? It only said it's going on for the last 10 years. So you please hear it like you heard in the first instance and then decide whether you should withdraw or should not withdraw. It's not like a firma that you put in one line. In a matter which is not a matter of 62, I'll show you now the provisions 42 and 62. Without in a misconceived tariff order, which has nothing to do with my case, and my case is a 42.
We have to consider it. Since the power is accepted by the single judge itself, we have to consider whether the procedure was already adopted by that commission or not.
And whether
What is the view taken by the division bench?
the division bench says everybody was heard. The public without hearing it, it was good enough. But the first point is, Lord, under 42 tariff, that order said that an application has to be filed for revision. It has to be either so put an application under 42, not without an application under 62 for general revision of tariff. Now kindly turn to this. Now see the section. Yes. See the section.
Don't link that.
Yeah. And I dare not to link both. Because you can have tariffs for different things.
That's what
you can have tariff for 42, you'll have tariff for 62.
There was a retail tariff order, there was a transmission tariff.
There is retail tariff, transmission tariff, all kinds of tariffs. You also find 42. Duties of distribution licensing in open access. It shall be the duty of a distribution licensee to develop and maintain efficient coordinated economic system in the area of supply to supply electricity according to the provisions contained in the Act. Now we are say 2. The State Commission shall introduce open access in such phases, which they did by 2006, subject to such conditions, which it did, including subsidies and other operational constraints may specified in the 1 year of the appointed date and specifying the extent of opening in successive phases and determining charges for dealing will have regard to all elements, including costs and so on. So this is what was done by below 2006. Open access was introduced, conditions were set out. 50 of the contract, 90 of the contracted demand was reduced to 51, etc., etc., etc. That is how it was done. So it is a specific clause in a specific statute in a specific situation. Now we don't have a look at 62 is completely different. This is below determination of, you also find it starts with 61, tariff. The usual tariff as we understand. Usual tariff, Lord, as we understand, is this tariff under 62. The appropriate commission shall determine the tariff in accordance to the provisions of that for supply of electricity by the generating company to a distribution licensing. So and so.
Retail sale of electricity.
Then Lord B, transmission electricity. C, bidding. D, retail sale. So retail sale will also provide say 4 rupees a unit or 5 rupees a unit, etc. Now, what should we find? Then it goes on to subclause 3, 4, etc. So this is Lord, you can have a tariff for transmission, dealing, retail, etc. Now this tariff of 2013, in which Lord this clause was slipped in, was a tariff for purposes of 62. It has nothing to do with 42. And 42 said physically, you have to do it, you do it below in 42. This is below determination of below the lordship knows. There are 2 ways. If we have a PPA, the PPA has to be sanctioned below by the commission. Or you have an auction method. In an auction method, there's no real determination. It's the auction price. So these are two ways to determine the actual price without a tariff. We have nothing to do with this situation. So that's this mix up. And once they have said that let there be a remand, then the remand should have worked itself out. And now I want to show you, Lord, it was specifically withdrawn, as Lord we said about Madras and windmill. At page 189 and 194. Just see, Lord, 189. A sample withdrawal for people situated like us, but using a slightly different fuel. Your Lordship will find this, Lord, 189. It starts. Kindly see, Lord, 189. 189 at 194. This is Lord for wind energy.
Yes.
Okay. It starts at 193. 193. This was the comprehensive tariff. We got 8.7.2.1 energy charge, then 8.7.2.2 demand charge, then it goes on, then at the foot. In the tariff order issued in 2006 and 9, please mark, concept of demand was introduced, which is at 51%, with a view to reduce the demand charges from 90 to 51. This is opposed by TANGEDCO as they are unable to recover full demand charge related to provision for all infrastructure facilities, as well as tying up the generating capacity. It's something like what we call a fixed charge, for somebody keeping his position ready. You pay something for that, apart from what you pay for electricity. Macros examined in detail, etc., etc. Now see 8.7.2.2.3, middle of the page. Keeping in view the above, the Commission decides to withdraw the deemed demand concept. Where is this word in my case? These words are conspicuously missing.
This was in respect of renewable energy.
Yes, that is Lord wind energy, Madras and all that. Now, Lord,
No, 1 second. It was challenged, Lord, before the APTEL.
by those fellows.
APTEL set aside that order of withdrawal,
This one.
the withdrawal. Then without matter was sent back to the commission. The commission again heard that withdrawal was right. Again went to the APTEL. APTEL again set it aside. The wind energy people, the Tamil Nadu is here. The board is here challenging that order of the APTEL.
So that's where people who are somewhat similarly situated, but using a different tool. Lord, this.
Petition, let us have your prayer.
That's right. Circular.
What? I'll show that. I'll show that. So now what happened with this?
Mr. Roti, what are you challenging the petition?
Yeah, I'll tell you what happened.
Just show us that.
Just
Yes.
let us have a prayer.
Show the prayer.
Yes. 319.
319. Lead item.
No, 1 minute.
319 is the letter.
Prayer.
That's it. That's it.
Prayer. I'll show you the prayer.
Only letter.
397.
Which phase?
We issued a letter, and in the letter we challenged. Only place where you withdraw. You never withdraw a tariff order. Why will I challenge?
You lordship will find. Lord, this was a specific challenge to a letter
To the chief financial officer.
issued by the respondents, which resulted, my lord, in this impugned provision.
Where,
Subclause
where is this letter? 29?
Yeah.
Yes.
319,
318.
318 it starts.
Make sure P10.
Lord, this is the sowing of the seed. You also will find at 318, see at 319 at the last point number 3. The seed is operating process. 319.3. From the above, it could clearly be observed that the concept of deemed demand has not been envisaged in the tariff of 2013. Hence, the applicable demand charge for open access shall be collected without applying the deemed demand. So this is a letter he wrote, and because of this, this has happened. It has to be by a tariff order, not by one officer sitting that I feel this has happened, and therefore you proceed.
No, what we think saying in paragraph 3 is
Yeah.
that this doesn't go on the tariff order.
No,
Then you have to change the tariff.
you have to
Tariff
get this
can
right.
challenge
The
only-
misunderstanding is that it was a retail tariff. It was not a 42 tariff.
Can I now?
From those words, he came to this conclusion that look, those two lines in without a 62 tariff really takes away the 42 concession, and therefore I feel that now bids should be raised at 90%. On this basis, without the bids were started being raised.
Just to add,
This is what is happening.
2006 specifically
Amulus, can we just?
under 42(2), and if you ever want to do away with this concession, move a petition not linked to the 62
Yes,
petition,
do it in
but
42.
under 42.
Yeah.
That's what 51.4.2, 5.4.2 is about. What the impugned order refers to is a 2013 order, which is under section 62, not under 42. So under 62, which is a generic tariff revision, you are dealing with 42, which is for open access and deemed concession.
No, no.
Tariff fixation is
Come to paragraph 26 of the division bench order.
Yeah.
Yes. Yes. Yes.
The tariff order of 2006 has been superseded explicitly in the tariff order for 2012.
26.
Can it ever be that an order passed under section 42, which categorically says that if you want to do anything under 42, move a petition separate from under 62. Then under 62, you pass a general order and say, I'm revoking, apart from the fact that it doesn't say I'm revoking. It's the letter which says I'm revoking. Unless it's important for your lordships for a minute to have page 49. Please have page 49 for a minute, my lords. If your lordships would be kind enough to have page 49 for a minute. Page 49. And this is the 2006 order, my lords. I just need to show this to your lordships. Page 49. My lords, has page 49?
Yes, sir.
This was the reason why 2006 under 42 came. Middle paragraph. The probability of occurrence of case number 1 is 0, and the probability of licensee supplying demand by so-and-so %. In such a scenario, whether the licensee is entitled to receive the demand charges in full, even though the generator is also injecting the demand into the grid, needs to be addressed. That was the object under 42, that if you are leading to introduction of electricity, why should you pay 90% of the sanctioned demand? Why should you not pay less to them? And after that, my lords, it is no doubt that all the fluctuation in the generator end and user end is met by licensee. However, the percentage of the demand injected by generator is also to be taken for consideration, and to that extent, the demand charges receivable by the licensees to be restricted till a mechanism is put in place to ascertain the relationship between demand generated, so and so, so and so. So a reasonable approximation has to be followed to arrive at the demand. And then, my lord, for a minute, please turn back for a minute to page 54 for a minute. My learned senior colleague, let it just have for a minute 54 again. My lord, has that?
Mr. Paul, at page 49 bottom,
Yes.
it says till a mechanism is put in place.
Yes.
What do you mean by a mechanism is put in place?
So under the 42, where this tariff order was passed, till a mechanism for how much should be the deemed demand charge
That is 51
is,
pull out with
or is to be put, they give their own examples and that is to be calculated in the meantime.
In other words,
How will it be done? Under which head?
They have given the formula, Manu.
Tariff, part of the tariff or not?
Yes, cities have.
It has to be a part of the tariff. See, how can they levy anything other than the tariff?
The word used is not ABT, alternative basic tariff, availability based tariff.
No, no.
In the tariff order, the word used is ABT.
No.
So till that comes, that is what it means.
Mr. Ranjit Kumar,
Availability based.
I'm not understood. Maybe
Sorry.
sorry. See, tariff can only be one. Correct. It is under 62 only they can charge. 42 cannot be a charging section. Are you saying that 42 confers a power on them to levy any other charge other than the tariff?
Subsection 2.
You see, according to me, as I understand, tariff can only be one. It can only be under 62. It cannot be anything beyond 62.
42
Well, it's, I,
gives them the power to give a concession. It's a 42 gives a concession.
For the charging, they have to be found in 62.
But that is the generic tariff section.
May I just explain your lordship's specific query, lordship?
well, it's, can I?
Lords, with respect to your lordship is right. Lord's tariff has
Dr. Singhi, you are on VC. You'll come last.
No,
It's only
I'm for the,
other-
no, I'm for the other side. Because I was hoping to get a chance on the other side, not the same side. I'm on the other side.
it just says this.
sorry, I took the petition in the High Court.
Lords, with your lordship.
You can explain.
Lord, there is- see, your lordship is absolutely right. 62 is the general tariff order.
There can only be one
There
charging
can be a
section.
tariff for a consumer only under 62.
Yes.
Now, 42, as Leonard Senior explained, is the right of open access.
Ah.
Now, open access is when I am not taking it from the licensee. I am taking it from my own third-party source. When I am taking it from my own third-party source, what am I doing? I am paying the charges for the facilities I am using of the license. So I am using the transmission wires, the distribution wires, and other things. So I pay for that facility. Just like there are two parts here, for energy and for demand. I also pay those charges for my own power. So what the commission said is, since as an example, you are using 100 units as a consumer. 60 units you are procuring from the license. 40 units you are bringing yourself. So for 60 you will pay the energy charges, but the demand is calculated on the basis of 100. So they found that not to be appropriate to pay the entire 100 for the license. What did they do? They said the 40 that you are getting, energy charge is a private contract. But with respect to the demand, because they are not, you are also bringing in that and you are paying those charges until we are able to exactly measure. Because to exactly measure what I am getting and when I am getting it, you require something called the ABT, availability based tariff meter, which will be at the generation end and at the consumer end. So only that will give an exact figure as to what is happening. So till that is done, they said, I can't decide how much you are getting or how much they are benefiting. We will restrict it to 50%. So really it was a benefit given to them because for a demand that I got, for which I am paying anyway the transmission wheeling charges, they said 50% you still pay him till we arrive at this conclusion. Therefore, 42, if your lordship sees, 42 is also a tariff fixing exercise for open access charges. So this is the, your lordship is right, retail tariff order, retail charges, open access charges for third party power. So when you are getting the open access charges, my lord, that is why Leonard Senior pointed out there's a specific order in 2006.
See, even that would have to form a part of the tariff.
No, my lord.
Yes.
It can only be a part of the, under the paragraph 62 only they can
No.
fix those rates.
No, my lord.
How will you fix it?
My lord, how it is fixed it, if your lordship sees 42, my lords.
Uh,
42, if your lordship sees,
Is there a separate exercise under
there is
that?
separate 42 exercise, separate regulations.
So who will do it?
Commission does.
It's back to square one, no?
Correct.
So
what
ultimately it goes
happens?
back to the,
Correct.
no one else can fix it.
Correct.
Only the commission can fix it. They must do it. So when the commission is fixing the tariff of 2013, it is addressing all issues.
No, it is not.
How will it be?
Because when it was fixing in 2013, it was fixing only the 62 tariff, the retail tariff. If your lordship sees what it was fixing,
See, the commission fixes tariff under all heads.
no, my lord.
It will have to fix even under 42.
Why separate order?
But the
If your lordship sees,
first
your
of all, there is only one authority which fixes the tariff.
Yes.
No second authority.
Supreme authority.
Same authority.
Same authority.
Authority, there is no problem.
Exercise is different.
Authority, your lordships are absolutely right.
Yeah.
That's the authority.
But
So question
exercise is
A,
different.
A under which section? B reasons. The regulations say reasons.
But the exercise is different.
If that is wrong, then you challenge the tariff order.
So at the end of the day, the question is this.
There are
Why was
tariff
51
orders which have come.
Why was 51 fixed as a matter of prudence? The key is the tap is one. From one tap, I get electricity from them and from them. Till you actually have a mechanism to know, my lord, whether it's 60-40, whether it's 30-70, and it changes every hour, every minute. So you need this ABT business to correct the tap. Till the tap is corrected, as a measure of open access of the 42, a concession was given till we measure, my lord, what goes in the tap and the prudence of 51. And therefore, this concession will continue till it is revived, is what 42 said. In the, even assume for a minute.
No, we are saying something separate. You see, therefore, we are
What's it
not
saying?
no. We are mistaking the power to levy this with the rightful determination of it. Correct, right?
Okay.
We are finding that there is a path. There is no problem on the power,
I'm also conceding that.
Right.
The 51 can become 30, can become
Yeah.
80 also.
right?
Subject to without checking.
What
Subject to checking, because the tap is common.
So
How much I take from them and how.
what the division bench seems to be suggesting
Yes.
that this is ultimately forming a part of the tariff order of 2013.
All right, let's proceed with that.
Now challenging that primary doc.
Yeah.
You cannot challenge just a letter. See, that letter flows from the tariff order. Yes.
But that,
Now, see, therefore, Mr.
that is
Mr.
content for retail, my lord. It's a
No, no.
retail.
See,
Under
ultimately,
62, what your
No,
lordship
that-
said was about retail also.
They are also retail consumers.
Retail.
But at the end of the day,
But I am
without
a.
it, even if you don't.
power is only one, the authority is only one to levy tariff.
Please take it. Let's proceed that way.
So, and it forms a part of the tariff of 2013, then you have to challenge the tariff. That's what the division bench is saying. That's what I followed from paragraph 25.
The reason why they did not challenge it because High Court.
Before the.
That is the reason. Therefore, they took a shortcut by
Can I just
challenging
go one
the
more?
circular.
All
It's
right.
a clarification.
Let me assume, in order to proceed with what Justice Manmohan is saying. Let me proceed with that. You can also turn for 1 second to page 41.
2 minutes, I'll say this.
41.
2006.
Mr. Gaitan wants to argue.
I argued the matter. But he was explaining.
I'm going to allow us to come.
2006.
One minute to come.
1 minute.
They are only caveat, my lord.
Don't explain.
Going on for one.
We will hear you. Let them finish that.
Because it's the first hearing, and we are only saying it's a matter which requires hearing. That's all we are saying. Turn to 41. At 40.
There are two sources of electricity, you said, no? We are also getting two sources, they're overlapping.
Yeah, correct. Major source we buy from outside because they can't keep.
No, I am also a producer of electricity. So I am doing captive consumption.
And not
That's
also,
what
there are
Producers are also here.
Turn to 41 for a second. Turn to 41 for a second.
Yes.
Now I'm proceeding on what Justice Manmohan said, that the tariff beyond will be fixed under 62. I'm proceeding on that basis. That is separate. Now we have the procedure for fixing for 62 is in 64. Just a minute. Turn to 41. An application for determination from my, lordship doesn't get the book. Okay, from the book.
It's in the paper book also.
page
Paper
41.
book also page 41.
It's also in the paper.
41.
Yes.
See 41. Procedure for tariff order. An application for determination of tariff under 62 will be made by a company in such manner, complete by such fee. The applicant will publish the application. The commission so date of receipt of the objection, issue a tariff order, reject the application. Applicant will be given reasonable opportunity within 7 days. They send to the government. Let's turn to the next one. Your Lordship finds subclause 6. A tariff order shall, unless amended or revoked, continue to be in force so and so. Now see Regulation 31. This is conduct of business law for a 64-62 case. Your Lordship will find B. The order, that is the tariff order, let us assume that the tariff order is the one which is in question not under 64, which may or may not include 42. Proceed with the basis. The order will contain a statement, counter statement, in brief, the points or issues for determination, the order thereon, and the reason. This will include dissenting conclusions, if any. Now, what it says is that one line, that's not 90% now. And why this is necessary? Because this was done not at the time when not the 51% came. Everything was done at 51%. All this. Same procedure applies to 42.
No, but anyway, see, you may be right.
Yeah.
That's what you have shown us, page 350.
Yeah.
Page 350 you go to.
Yeah.
Right?
Yes.
They have said at page 350, 90% will be there.
So by one line.
Whatever, 1 line or 0 line, that
That's
is
correct.
unreasonable.
Right.
To challenge this.
But
The
without the
problem today is this. See, what he's putting is a valid point. That's what we are actually discussing.
yeah.
See, you have to challenge the tariff. The problem is the tariff cannot be challenged by way of a writ petition. Right? So you have gone to the wrong forum. That's what we are discussing.
Then they got a stay. It's continued for some time.
What we have to consider is whether the effect of the tariff order can be bypassed by challenging a communication.
Manoj, I tell you, not challenged.
It has to be challenged before the.
Lodges, I tell you, Lodges, why the tariff order was not challenged. Manoj, the tariff order was not challenged. Manoj, the tariff order. Manoj, the tariff order was not challenged for two reasons. One, it nowhere in terms of 64(6) says that the earlier tariff order is revoked. One. Secondly,
Doesn't have to say that.
Manoj, 64(6) categorically says, Manoj, if I can do without
New tariff.
Alternate remedy.
amendment or revoke. Now, my lords, your lodges have time and again said it's not a constitutional bar.
It's not a
It may be an appropriate case where natural justice has been violated, where proper reasons are not given. I can always come in a request.
After two decisions on merits.
challenge it. No.
But today now to go back all the way.
And 7 years, 7 years of stay
After 7 years have gone
in
back.
our favor.
Your lordships have never, after 7 years, told a party, I can understand.
They are right about that, Lord, because after 3 years,
May I say?
after the 2013 order, there have been 7 orders.
Milord, I want to make a submission without you.
I'm only saying, not a 226. Even though, Lord, suppose you could do that. Once you have done that on merits, there are two judgments. Now to say, start another litigation, Lord, after so many years, that may not be correct. The lordships have done
I have
on
a,
so many occasions.
Manoj, I have a detailed single judge's order in procedure.
Nothing
By
is done.
an order of the single judge on natural justice, just show 4 paragraphs.
This is-
Please say 4 paragraphs.
They don't follow the law.
Manoj, please
I
have,
to go into
please, my lord, that the single judge's order, if your lordships feel that doesn't have merit and the weight has been upset, could have been done. Just have the single judge's order, my lords, for a minute. Just give me that for a minute, my lords. Kindly have page 445. Please have para.
445? You're in some other paper book. I think.
No, my lord, I'm in item 55.
Just turn back to all these pages. Same.
Very well, my lords. Para na.
445 is the cost rate. Therefore, I am saying 445 is the cost rate.
Yes, my lord, no, I'll have the same one Mr. Romki was reading from.
Yes.
I'll show, please have para 9 onwards. Let me just read these 3 or 4 paragraphs, my lords. This is of some significance.
Page 419. Mr.
Yes.
Yes. Refer to it.
Yes, yes. My lord, let me just read these paragraphs if you have some significance. Yes. Considering the arguments advanced on both sides, this court is of the opinion that admittedly the concession of deemed demand charges were granted to all these writ petitioners by way of an order by so-and-so commission in so-and-so 2006. The preamble of the order categorically enumerates that an adjudicative process had been conducted and written objections, suggestions consulted. The members of the State Advisory Committee heard the issues raised by the stakeholders by way of public hearing and were obtained before passing the order. This court is of the opinion that such concession granted to these writ petitioners is of the opinion that such a process ought to have been conducted before withdrawing the concession granted to these writ petitioners. Concept of implied withdrawal can never be accepted in view of the fact that through an agreement the concession was granted and it is contractual in nature. The petitioners are generating electricity power in keeping the same for their own usage. The service of the electricity board is also utilized by these petitioners for transmitting electricity power. Thus, undoubtedly, all these conditions were considered by providing opportunity to all the parties, and the decision was taken by Tamil Nadu Legislature. Such being the factor, while withdrawing the concession, it is necessary on the part of the Electricity Board to approach the Electricity Regulatory Commission by filing a proper application or with a request to initiate suo motu revision under 5.24.2 of the said order dated 15/5/2006 and respect to access customer fossil fuel based generators. Then please have 10. This court is of the considered opinion that when certain concessions are granted for a close group of people by way of adjudicated process, the said concession can be withdrawn only by and water and wind energy, etc., where it was a more detailed order than in our case. Even there, as Mr. Ranjit Kumar rightly pointed out, the Act has set aside those orders repeatedly and sent it back if you have not followed the procedures.
Because the tariff orders were under challenge.
No matter
If you have not done
Yes,
that,
yes,
so it's
yes.
natural justice.
I want to make one
You want to
suggestion.
go to appeal.
Correct.
Yes.
In many cases, the doctors have entertained without.
I'm in 56, may I just say two things?
Yes.
In the counter affidavit filed by the commission before the Honorable High Court, if your lordship just come to page 419 and 423, para 7. It's in the same volume which your lordship has just now referred to.
The commission's law.
It is the commission's counter, starts at 419.
You are referring to which paper?
55 and 57. Both which my friends have been referring to. Not, I'm not.
All right.
Of course, I'm referring to my paper. But I'm taking the page number.
Yes.
So, my lord, may I just request the lordship to come to para 7, my lord? This is the commission's counter. May I just place 5-6 lines of this, my lord? My lords have it, my lord?
Para 7?
Yes, my lord.
Yes.
Justice Manmohan also has. Yes, grateful, very okay. It is further submitted that the concept of deemed demand was introduced by the Commission in the open access charges order issued on 15/5, order on transmission and billing charges, etc. This is what Lord 42(2) says about giving cross subsidies, etc., etc., with a view to reduce the demand charges for open access consumers. However, this order was superseded by the next order on open access charges issued on 30/3/12, order number 2 of 2012, dated 33. Not 2013. The order which is now being referred to is the 2013 order number tariff order number 1 related to trade. This order has not provided deemed demand benefit to open access consumers. Such a decision was taken by the Commission, taking into account the views of the TANGEDCO that they are unable to recover the full fixed charges through demand charges by providing deemed demand benefit to the open access consumer. When the captive or merchant power plant, that is like me, not generating adequate power, the licensee is obliged to supply the required power to the respective captive or the third party consumer. Now, this order, which my dear friend has referred to, does not contain all this consideration. This is what the Commission's affidavit is showing. And the affidavit is of regarding 2012 order. 2013.
No, this directly answers
Just a commission stand 425.
Sir, Justice Manmohan's query. The lordship asked that section 42 order, was it replaced by a 62 order? No. The commission itself took the position that my 42 order was replaced by a 2012 order. When they found that the 2012 42 order makes no reference also to this deemed demand, they changed the, and before the single judge, they relied on this. Single judge said, where is the order? That is why the single judge says, there is no order withdrawing it. So the commission has to consider afresh. There can't be a deemed demand. Very cleverly, what they do is they take this position in counter, they take the position before the single judge. In the division bench, yes, they change the story. It's the classic MS Gill story. They change the story and say that the open access charges are withdrawn under the tariff, consumer tariff charges under section 62. The reason why we did not have to challenge the 62 order was 62 is retail tariff order. Even the commission itself does not say initially that the 62 tariff order withdrew this.
No, the act does not postulate two tariff.
It does, my lord.
No.
It
There
is
no
the commission
separate
itself
tariff.
says.
There is no separate tariff order.
No, where there is a,
There can be one tariff order. See, page
no,
315.
page 61, your lordship.
See, Mr. Counsel, page 315 stares you in the face. 315 specifically deals with, suppose it is a part of 42 tariff, it is dealt with in the main tariff order.
It is not.
You have to challenge it.
No, may
The
I-
moment you don't challenge it, there will be consequences.
Well, will
You
you
can't
not-
just catch hold of that letter which has been issued in pursuance to that page 315 and challenge that.
May I just explain that, my lords? Your lordship has, your lordship has seen that billable demand. That billable demand is a concept which has been there right from the beginning, even in 2003. And that has nothing to do with transmission, my lords.
No, that
What is
so,
billable?
But once it is a part of the
No, it is
challenge
not.
it.
No, may I say this, my lord?
Challenge it.
No.
The only problem is you got to the wrong forum.
No, we have probably not been clear, my lords. If your lordship just gives me 2 minutes, my lords, I'll explain that. My lords, what has happened is, my lords, there is a 42 tariff order for the open access consumers, which is a separate line of charges, separate way of dealing, because this relates to the procurement of open access. Deemed demand is under open access. There is a separate line of tariff orders under section 62, which is as a consumer, what I pay. Now, this 62 billable demand does not deal with this at all. What is billable demand, my lords? Senior pointed out, my lords, that a consumer pays a two-part tariff. He pays energy charges and he pays demand charges. That is a two-part tariff. Energy charges for the actual electricity consumed, demand charges for the infrastructure which is created. Now, this infrastructure which is created is there whether I use the power or not. Therefore, my lords, that billable demand, that concept of billable demand is you will pay 90% of those charges when you are a pure consumer. So, you pay 90% of the charges I will pay as a consumer. But that relates, in my example, to the 60% of the power I procure. So, 90%, whether I use it or not, I will pay 90% of the 60% of the charges which I do it. So, it is a separate retail tariff which I pay. This is under an open access charge, and that is why the commission also, my lords, the commission was aware of the position that these operate under separate silos. It is the same commission which decides, but it operates under separate silos. So that's why before the single judge it took the position that my 2006 tariff order was replaced by my 2012 tariff order, which does not speak about it. So they were caught with their pants down. So in the, I'm sorry to have used that expression. What they thereafter did was, before the division bench, they changed the story. They changed the story by pointing out that it's a billable demand, and that has replaced. You can't, when a license, the licensee takes a different view. Licensee says 2013 tariff order. The commission takes a different view. It says 2012 tariff order.
No, I
For
think
transmission.
Same stand we took.
My lord,
From 2012.
that's a
we
counter.
discussed-
Let me finish.
We have removed the
Let me
concession.
finish.
Look, there's a government of Tamil Nadu direction also.
My lord,
And you have
let
brought
me
a
finish.
section 108 saying that withdraw the
My
concession.
lords, in the 2013 tariff order, my lords, the regulator says 2012 transmission order. Your lordship will look at the position of a consumer. A consumer says, I still have the right. A letter comes in.
We are not doubting that you can't challenge it.
No, I can.
You have full liberty to challenge it.
Look,
The only question is,
No, I'm just coming to that.
the right forum, and have you challenged the right?
No, I'm coming to that.
No, no.
No, precisely that is what, my lords. It's a valid question which I'm duty bound to answer. What has happened is, my lords, because there are separate orders. Till the letter comes, my lords, in fact, my lords, 2012, 2013, we continue to pay only the 50% charges. 2013, the circular is issued to everybody. We see the circular and say, Arey Baba, there is no withdrawal. How are they saying that? We come to the court. Court says, yes, there is no withdrawal. The commission has to do it. Because there is no, in a retail tariff order, you will look at this position. Today, their stand is the retail tariff order of 2012 withdrew deemed demand.
You see, the letter that you impugned in the writ petition was of July 29, 2013, July 29.
Yes.
Now, the tariff order came into effect on 20th of June 2013.
Correct.
So it's basically a consequence of the tariff order.
It is not.
The tariff order, you
No,
cannot.
no, please see the commission's own stand. Please see the commission's own stand.
Then permit us to at least file an appeal and let limitation be not held against us. It's my argument there.
At that you filed your
Petition
Milord, let me then file an
Obligements.
if this is all.
Well, Madras High Court.
Allow us to
They
file.
can't do it.
Well, we are.
Milord, see there.
You file your appeal.
Like, withdraw this and file in a.
But why
And
are
Madras protect me for 4 weeks because we have an order.
Malas, kindly don't Malas give interim orders and Malas give them after the matter is dismissed. My learned friend wants full relief, Malas.
They should be allowed to.
Any word by your lordship has a lot of impact, Malas.
Can't be that guy.
Malas, they have 600 crores pending. I have no hope of recovering it. They've got 600 crores pending, Malas. I have no hope of recovering it.
Yeah.
Because they got an interim order early on. They've not paid me a penny. It's 5 crores per month. All of them
In
collectively.
these bunch of appeals, petitions, in these bunch of special leave petitions, the order of the High Court allowing the intra-court appeal preferred by, what is this?
the respondents are in?
Preferred by the first respondent is the challenge.
Both were not.
The TANGEDCO just take down the details and post down. The division bench of the High Court, upon appraisal of the materials placed on record, took the view that the writ petitioners had challenged a communication letter based on a tariff order dated 20th June 2013. Full stop. As there was no challenge to the tariff order, comma, the petitions were dismissed by the division bench by allowing the appeal and setting aside the order passed by the learned single. Full stop. Paragraph. After some arguments, comma, the learned counsel for the petitioners pray to withdraw these petitions with liberty to challenge the tariff order before the appropriate forum. Full stop. In such circumstances, we deem it appropriate to dismiss these petitions as withdrawn with liberty as prayed for. When you apply, then limitation question will be
That's
considered.
They should not disconnect on 12.
No,
Now is the week time.
We are not passing any interim order. We are only making an observation. All contentions are left open for the parties.
Yes. Obliged. Right. Obliged.
We also have a contention. The challenge is now to the challenge which they propose to make is the 2013 tariff order, which has been superseded by subsequent 2017, 18, 19.
Then we are.
Therefore, if they please.
We'll do whatever we have to do.
They will know the demand, they will.
Obviously, we have knowledge about this. But doesn't matter.
Hold on.
These all contentions.
Hold on.
Let them file an appeal. Whatever order they want.
Listen, any word by your lordship, a lot of weight, Malas. Please don't say anything.
Protection continue.
Why can't they make a submission? Please.
12 years I have had the protection and we have paid 50%.
No, we are not.
Like it.
You go.
Malas, that arrears of 50% is 600 crores.
All contention by parties. This is difficult.
Yes.
All contention by parties, including a contention on our part regarding maintainability of the available.
All contentions on both sides.
All contentions, including the maintainability of the appeal.
Obliged.
The parties.
Obliged.
Only one question. Only one question.
Till we file in the next 3 days. Let them not disconnect.
No, Malas, this is not fair. They have a stay.
Hard spinning withdrawal.
3 days we'll file.
SLP be dismissed and yet they get the benefit.
Given an interim protection by the High Court or not?
Yes, my lord.
Malas, the arrears of 50% is now 600 crores. And per month, current charges are 5 crores. They don't even pay current charges.
90 days to pay me. So 3 months. The High Court has said 3 months period to pay. To pay. Not months course, no course. Last 4 lines of the judgment, last 4 lines.
From
Well,
2014.
Any charge.
This should be left to the new tribunal, Malad.
3 months time. It's already given.
Expiring on 12th. All that we are saying that in the next 3 days,
March
we'll
is
file it.
expired.
3 days we'll file it.
Malad, after losing in DB and Supreme Court, they should not get any stay.
I think the order that we have passed is final.
Obliged.
Permission to file special.
Some protection can be
In
given.
item number
No,
55.
Malad, again and again, the same thing is done.
Grant kar di for
A lot
Plus
of
3 days and we
applications
could be
for
given protection.
improvement in intervention also.
all disposed of.
You already have.
It's an order of December. It was uploaded after a month. Actually, we have protection till April.
Malad, how many times can a review petition be made now, Malad? This is the fourth
Take
review.
your application, move.
Fourth
stay
review.
application. If it is rejected, you come here.
Wait, 12th is disconnection. That's our difficulty.
That's the difficulty.
We are not going to
This
pass.
kind of a pressure tactic.
Yes.
Not
Deeply obliged.
If you wait
Not
that
from
long,
the
you can't help it, yes.
No, not sure. Item 62.
Ah, great.
61 till done. Item 62.
Milord, there are also a set of other matters which were filed. Milord, it will suffer the same fate.
100 cases they have filed.
No, all bunch in entire.
No, further.
No, what?
We can dispose of it.
हाँ, इसको भी समन कर लीजिएगा, taken on board.
We are okay.